Hello everyone, I'm Farhan Fauzy and will explain to you the result of my critical review of a journal. The journal I chose is titled Pacta Tertiis and the Agreement for the Implementation of the Provisions of UNCLOS 1982 relating to the conservation and management of straddling fish stocks and highly migratory fish stocks. This journal basically assessed the Pacta Tertiis principle in the light of the implementing agreement to the UNCLOS 1982, specifically relating to the conservation and management of fish stocks. So I'm gonna tell you first the summary of the journal. So UNCLOS 1982 is deemed as the ocean's constitution, and it is a package deal treaty which no states, if non-party states can reserve to this treaty because it aims for something big to a global cause. So for it to work effectively, no reservation are allowed. And then UNCLOS tried to accommodate all state members to regulate the seas, all the 168 parties, but it's hard to keep up with. Uh, uh, you guys, I hope you guys pay attention to the number of state parties to UNCLOS. It's 168 parties because we are gonna assess further regarding the parties to the subsequent implementing agreement, the 1995 agreement, which will be discussed later. And yeah, to accommodate these states, adjustments were made through many ways. The first one, there's an UNGA resolutions. The resolution made an annex to this treaty, and there's the second way, which is the subject of this review. It's the 1995 agreement. This agreement is a separate treaty. It is not annexed to the UNCLOS. It is a separate treaty being made and being entered into force after the UNCLOS has entered into force also. So yeah, let's continue. Pacta Tertiis Nek Noksen Nek Prosun, or for Pacta Tertiis for short, is a principle in international law that said that an agreement concluded between two parties shall not create rights and obligation towards non-party. It is a customary international law that also being enshrined in the Article 34 of VCLT. Is this rule still relevant? And I quote from the journal that says that it may not as strict as once believed. Why? Because the tragedy of the this answer is based on the field of high seas fisheries, where tragedy of commons resulted on the undermining of international law rules. The tragedy of commons is when states use or harvest limited resources in the seas or in the environment, that they use it not using a right calculation. So several states that overuse it may affect other states that use it rationally. And and the states that over harvest the resources will defend themselves by saying that I'm a persistent objector of this rule. I'm a persistent objector of this customary international law. So I am creating my own customary international law. That is what's their defense towards these issues. And the 1995 agreement is, like I said before, is implementing agreement of another treaty, which is the UNCLOS in the field of fisheries. It only has 90 parties compared to the hundreds parties of UNCLOS. There are three views whether this Regarding this 1995 agreement, first one is this agreement is fully consistent with UNCLOS. Second one, it goes beyond UNCLOS, but it's still in the same context. A third one, it contains inconsistency from UNCLOS. And then we're gonna discuss 3 articles that are worth discussing that the journal said. It's Article 8.4, Article 21, and lastly Article 23.1.2. Article 8.4 of the 1995 agreement provides a new principle that only gives access to fishery resources in certain area of the high seas that are it's exclusive only to members of competent sub-regional or regional fisheries management organizations. I'm gonna give you a context first that high seas is res communis, where no one can claim ownership on the high seas. Everyone can utilize resources there to some extent, but it cannot be exclusive to certain people, to certain states. And that's according to UNCLOS. But in this 1995 agreement, it provides that regional fisheries management organizations or this organization that are concerning fisheries that is based on regional level. So, for instance, the Inter-American Fisheries Management Organization. This agreement gives rights, two exclusive rights to the member of such fisheries management organization to harvest fishery resources in that area. So that certain area is off limits to non-party to the regional fisheries management organization. And it is quite controversial for sure. Does it violate Pacta Tertiis though? No, because in practice, the term state in this article only applies to the party of the 1995 agreement and not applied to the state that is only party to UNCLOS. You see that the UNCLOS is 100 parties and the 1995 agreement only have 90 parties. So the parties to the 1995 agreement is obviously the party to UNCLOS, but the party to UNCLOS is not per se the party to the 1995 agreement. So you guys might imagine how the Pacta Tertiis can be seen here. Article 21 of the 1995 agreement, the second article that we are going to discuss. It provides that ships may be boarded and inspected on the high seas by a member of a regional based organization to check whether that vessel is a party belong to a state party to the organizations. So let's give a let me give you example of the previously used example, the Inter-American Fisheries Management Organization. That is the region is in the America, and say Indonesian vessel pass that region. If according to this agreement, the party to the Inter-American Fisheries Management Organization may inspect and board Indonesian ship, Indonesian vessels. This is in contrary with what is being established by customary international law, as well as the provisions in UNCLOS, which state that only flag state that can have jurisdiction, or that only flag state that can board and inspect the vessel on the high seas. So if Indonesian vessel are on the high seas, only Indonesia are capable on boarding and inspecting those vessels. That is according to SAIL and UNCLOS. So there's a difference here. And does it violate Pacta Tertiis? Somehow, yes, it violates Pacta Tertiis. But the point is, which will be discussed further, is the violated state or the party to the 1995 agreement only consented to be violated. It violates Pacta Tertiis because state party to 1995 agreement may be bound by the regional fisheries management organizations measure which they are not bound of. For example, this is a hypothetical example. So if Venezuela is a party to 1995 agreement, but is not a party to the Inter-American Fisheries Management Organization. Venezuela located in American continent. So if Venezuela are consented to these provisions, then Venezuela are also indirectly bound by the Inter-American Fisheries Management Organization. So it clearly violated Pacta Tertiis rule. But then we can see that Venezuela agreed to be violated. We will discuss about it further later. And lastly, Article 23(1)(2) of the 1995 agreement, it doesn't only grants the port state the right, but it also gives obligation to promote effectiveness of regional and global conservation and management measures. UNCLOS 1982 only grants rights. UNCLOS grants obligations in the marine pollution regime, not in fisheries regime. So does it violate Pacta Tertiis? It is unlikely to be bound to non-state party because it has not yet been crystallized into customary international law. So it is unlikely that this article violates Pacta Tertiis. What's interesting in this journal? There are three things that are interesting. The first one is the status of the 1995 agreement and whether it violates Pacta Tertiis, which we already discussed that before in a brief. And the implication of the 1995 agreement towards the third states or non-state party. What's the effect of this agreement and such. And last one is the subsequent treaty or other instruments to implement another treaty. I will give a comparison to another case other than this UNCLOS and the 1995 agreement. Well, to summarize, that Article 84 doesn't violate Pacta Tertiis because it was interpreted in a good faith and it is basing on the context, object, and the purpose of the 1995 agreement. So this interpretation method is written in the Article 31 of VCLT. Then it is not violating Pacta Tertiis because it is interpreted in good faith. I mean, it based on the context. Article 21, it violates Pacta Tertiis. However, the interesting part here is the violation only applies to state party. If Indonesia is a party to the both UNCLOS and 1995 agreement, then Indonesia are consented to be violated towards the Pacta Tertiis rule. But if Malaysia, for example, is not a party to 1995 agreement, then there's no violation of Pacta Tertiis there because the provisions doesn't apply to Malaysia. The Article 21 doesn't apply to Malaysia as a non-state party to the 1995 agreement. It is because the consensual nature of international law that any states, without violating jus cogens, of course, that can do anything. I mean, even if we see at customer international law that it's basic contract law that they can do anything as long as the limitation here is not violating jus cogens. So it's the consensual nature of international law that makes this violation is how do I say this? The violation, there's no good reason to object to these provisions because even the violated states are consent to the being violated. And lastly is the Article 2312 of the 1994 Agreement. This is unlikely being accepted by third party as it is not yet crystallized as seal. Second is the position of non-state party to the treaty that if it affects them in some way, like Article 21. So if a non-state party being affected by another treaty, there's two ways to see this. Firstly, the third party is not bound by such treaty unless they are already consented to be bound to it. It can be seen in the previous assessment of Article 21. And secondly, it may be enforced to non-state party only if it has become a seal. It can be seen in the Article 2312 analysis, but it actually doesn't apply. But the provision in treaty doesn't really apply to the non-state party per se. The thing that bound the non-state party is the seal, the customary international law, which have the same values as the articles in the treaty. There's a similar practice for this Pacta Tertiis thing in the regime of Rome Statute. Rome Statute is the treaty for establishing ICC as well as the materials or the jurisdiction, etc. We can see the jurisdiction of the thing that we are gonna focus on is the jurisdiction of ICC, particularly Article 12.2a of Rome Statute, that says that the court only can have jurisdiction if the party, the state where the territory of the conduct in question occurred is either a state party or it is states that accepted the jurisdiction of the court. For example, Indonesia is a non-state party and Bangladesh is a state party. So if the genocide happened, address one of the four most serious crimes under the ICC jurisdiction happens in Indonesia, then it cannot be brought to ICC because Indonesia is not a state party. This is the conventional way to interpret this. Yes, and on the contrary, if it happened in Bangladesh, a state party, then it can be brought to ICC because the conduct in question occurred in state party. But there's a development of these terms because in Kampala amendments, when ICC, the Assembly of State Parties to ICC, amends Rome Statute when they want to add crimes of aggression, the Special Working Group report shows that conduct in question shall also includes the consequence of the conduct. So conduct in question is conduct plus the consequence. This broadened definition opens the possibility of non-state party being subjected into ICC jurisdiction by virtue of Article 12.2a of Rome Statute. For example, the situation in Myanmar and Bangladesh. This is not a per se a case yet in the ICC, but the judge already issued a decision. The pretrial chamber has issued a decision on this matter that basically said that ICC does have jurisdiction in the Rohingya case in Myanmar, which Myanmar is not a state party, because the crimes of deportation, crimes against humanity in the form of deportation, started in Myanmar, but it produced an effect in Bangladesh. So Bangladesh, as a state party, are affected by the crimes of deportation, which it includes under the jurisdiction of ICC. So this is a similar case because even non-state party to ICC can be subject under the court's jurisdiction. It is similar to the 1995 agreement case before, particularly Article 21 too. Article 21 because yeah, they bound the bound states that are not a party to the regional organization to their provisions. So yeah, that's all for my presentations. And if you have any questions or discussions, feel free to uh, include it in the comment section below, and we will have a discussion below. Thank you very much, and see you.